Again.
The Committee on the Judiciary Subcommittee on the Constitution, Civil Liberties, and Civil Rights will come to order. Without objection, the chair is authorized to declare a recess of the subcommittee at any time. I welcome everyone to today's hearing on the implications of Burdic versus Democratic National Committee and potential legislative responses. I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. That would be judiciarydocs@mail.house.gov. And we will distribute them to members and staff as quickly as we can. Finally, I'd ask all members and witnesses to mute their microphones when you're not speaking. This will help prevent feedback and other technical issues. You may unmute yourself at any time when you seek recognition. I will now recognize myself for an opening statement. Rights are only as strong and meaningful as the ability to enforce them. Among the most fundamental rights in our country is the right to vote, free from discrimination based on race or ethnicity. And at a time when American democracy itself is under severe threat from demagogic forces, and there have been a tidal wave of voter suppression efforts in many states since the 2020 election, it is all the more important that we in Congress help facilitate strong and expansive enforcement of voting rights. And no statute is more central to this effort than the Voting Rights Act of 1965. Yet 2 weeks ago, the Supreme Court's conservative majority reiterated its hostility to the VRA's central purpose of eradicating race discrimination in voting by further undermining the Act's enforcement mechanisms in Burdic v. Democratic National Committee. In reaching its decision, the court compounded the damage it inflicted on the Voting Rights Act in 2013 when it effectively gutted the Act's most powerful enforcement mechanism, its pre-clearance requirement, Section 5 in Shelby County v. Holder. In Burdic, the court upheld 2 Arizona voting measures in the face of legal challenges brought pursuant to Section 2 of the VRA, alleging that these measures denied or abridged minority citizens' voting rights on account of race or ethnicity. That's what this Section 2 is about. In 1982, in response to an earlier Supreme Court decision restricting the scope of Section 2, Congress wrote the current version of Section 2, deliberately choosing to use very broad and expansive language. Section 2A provides that no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision in a manner that results in a denial or abridgment of any citizen's right to vote on account of race, color, or language minority status. Section 2B provides that there is a Section 2A violation when, based on the totality of the circumstances, it is shown that the political processes of the state or locality are not equally open to participation by minority citizens. That means that minority citizens, quote, have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. In 1986, the Supreme Court in Thornburg versus Jingles adopted a list of historical and social factors taken from a Senate report on the 1982 amendments to Section 2 that courts should consider when assessing whether, under the totality of the circumstances test, a voting rule violates Section 2. Taken together, this expansive rules test has now been in place for 4 decades. More troubling than the outcome in the individual cases at issue at Burdic was the reasoning underlying it and its potential impact in future cases alleging vote denial claims under Section 2. In a brazen opinion, the court in Burdic created out of thin air 5 guideposts that lower courts are to follow in assessing vote denial claims under Section 2. These guideposts are found nowhere in the Voting Rights Amendment or Voting Rights Act, directly contradicts Section 2's purpose, and potentially narrows its scope. As Justice Kagan wrote in dissent, the court was operating in a law-free zone. Or this was an activist court not relying on precedent. Depending on how lower courts interpret and apply these guideposts, any one of them can become a giant loophole for states and localities to discriminate against minority citizens. Taken together, they can present a formidable obstacle for future Section 2 plaintiffs alleging vote denial claims. One particularly offensive example is the, quote, size of this disparity, end quote, guidepost. under which the court concluded the small disparities in the burden imposed by a challenged voting rule are less likely than large ones to indicate that the election system is unlawfully discriminatory. Kind of like a light violation of the law. Put another way, this can be taken to mean that imposing a little bit of racially disparate burdens in voting is okay. That is really amazing. Of course, Section 2 contemplates no such de minimis exception for racially discriminatory burdens in voting. Section 2 allows for no voting qualification or other practice or procedure that results in denial or abridgment of the right to vote. In essence, strict scrutiny. Moreover, how does one assess when a racially disparate burden is small enough not to matter? Just a little bit of discrimination, just a little bit of racial animosity and political politics over race and justice and equality. The court provides no answer, leaving the door wide open for voting rights defendants to make the argument and for lower courts to accept that many kinds of racially disparate burdens are too small to violate Section 2. In a similar vein, the court created a mere inconvenience exception to Section 2, concluding that an assessment of a Section 2 vote denial claim had to account for the usual burdens associated with voting, and that such ordinary burdens did not implicate Section 2. Of course, Section 2 recognizes no such exception. Moreover, this guidepost puts the cart before the horse. The whole point of a Section 2 inquiry, one focused on the interaction of a given jurisdiction's historical and social conditions with facially neutral voting rules, is to determine whether such a voting rule, which might impose a mere inconvenience or usual burden on white citizens, might have a discriminatory effect on minority citizens' voting opportunities. Without such an inquiry, no court can objectively say whether a voting rule imposes a burden that is merely inconvenient. The court's decision in Burdic is deeply troubling because of its implications for Section 2, what we had left of the Voting Rights Act after the emasculation in 2013. It heightens the risk that future Section 2 plaintiffs in vote denial cases will have a harder time prevailing. It did, however, leave Congress with the option to respond with a legislative fix. We would welcome suggestions from our witnesses to how to best respond to this problematic decision, other than redistricting the Senate. I thank our witnesses for participating in today's hearing and look forward to their testimony. And now I'd like to recognize the ranking member, who today will be the gentlelady from Minnesota, Ms. Fishback, for her opening statement.
Thank you very much, Mr. Chair. Today's subcommittee hearing is about the decision at the Supreme Court's decision in Burdic. And this is now the fourth hearing this subcommittee has held on the Voting Rights Act since April. Today, we will hear the same talking points which are being repeated daily in the mainstream media. I don't know anyone who wants to prevent minorities or anyone from voting, but I have many constituents who are calling on me to protect the integrity of our elections. Let me be clear. Republicans want every legally cast vote to be counted and want every election to be free from fraud and error. There are many common sense ways of doing this, which I think many of us could agree on behind closed doors and away from the cameras, including the provisions from this case. With this decision, the Supreme Court refused to politicize the Voting Rights Act and to transfer the authority to regulate elections from the states to the courts. As we know, the Election Clause of the United States Constitution gives state legislatures the authority to prescribe the times, places, and manners of holding elections. And that is simply what Arizona did with its out-of-precinct policy and ballot collection restrictions, both common sense measures that uphold the integrity of their state's elections. The DNC disagreed and tried to politicize the VRA by challenging these measures under Section 2. On July 1st, 2021, the Supreme Court issued its decision, which presented the court with its first opportunity to weigh in on the VRA's Section 2 claim that challenged voting laws regulating the time, place, and manner of casting a ballot. The court held that Arizona's regulations governing out-of-precinct voting and ballot collections did not violate Section 2. Although Justice Alito did not announce a test to govern all similar VRA Section 2 challenges, the court found that equal openness of election procedures remains the touchstone in establishing whether there is a violation of Section 2, and courts must examine the totality of the circumstances. The court reiterated that states have a compelling interest in preserving the integrity of its election process. The court received a letter from the Biden Justice Department agreeing that the case presented no VRA Section 2 violations. I look forward to discussing the implications of this case will have on future Section 2 litigation. Like the Shelby decision, and contrary to misinformation, this decision does not gut the VRA. Even after this decision, Section 2 remains an effective tool to stop racially discriminated voting laws. However, the decision denies its critics the opportunity to use the VRA as a partisan tool to stop policy decisions and that they simply disagree with. Following the 2020 election, several states have passed common sense election integrity reform measures, which I again think we could agree on many of them behind closed doors. Unfortunately, we have already seen a false narrative pushed surrounding election integrity efforts in an attempt to build a false record of voter suppression to build momentum for amending the VRA. It is disheartening that politician groups and legislators are being maligned as trying to harm the very elections they are trying to secure. For example, just look at the Biden administration's Section 2 lawsuit against Georgia. Georgia's common sense election integrity law is being attacked as discriminatory. Instead of attacking the motives of good Americans on both sides, we should be working together to ensure that minorities are protected from discrimination and that our elections are secure from fraud. I look forward to discussing this landmark voting rights decision today, and I thank all of the witnesses for being with us today, and thank you, Mr. Chairman. I yield back.
Thank you, Ms. Fishback. I appreciate your opening statement and your filling in for Mr. Johnson today. It is now my pleasure to recognize the full committee chairman, the gentleman from the great state of New York, the Empire State, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate your holding today's hearing to consider what action Congress should take in response to the Supreme Court's recent decision in Burdic versus the Democratic National Committee, which significantly narrowed the scope of Section 2 of the Voting Rights Act of 1965. Section 2 prohibits voting practices or procedures that discriminate on the basis of race, color, or membership in certain language minority groups. While the extent of the fallout remains to be seen, the Brnovich decision appears to have significantly undermined Section 2's voting rights protections. Specifically, it will likely make it harder for plaintiffs to prove vote denial claims under the results test, which Congress adopted in 1982 as a guide for courts to determine whether the plaintiff has established that a challenged voting practice violates Section 2's prohibition on discrimination when the challenged practice, while facially neutral, has a discriminatory effect. One silver lining to this decision, however, is that it leaves Congress with the ability to undo any potential damage the court has inflicted on Section 2. That is because the majority's opinion in Brnovich is based solely on its tortured interpretation of Section 2, which is unsupported by the statute's text and is contrary to its purpose, and which Congress can correct through legislation. Congress included Section 2 in the Voting Rights Act with the important purpose of protecting minority citizens from racial discrimination in voting in those areas of the country that were not subject to pre-clearance under Section 5. In 1980, in the case of the City of Mobile versus Bolden, the Supreme Court interpreted Section 2 to prohibit only those voting measures that were motivated by a discriminatory purpose, narrowing what had been the then understood scope of Section 2. In response, in 1982, Congress amended Section 2's language expressly to broaden its scope. Congress was concerned that state and local policymakers were implementing facially neutral voting practices, like those affecting the time, place, or manner of elections that could interact with underlying social conditions created by historical discrimination to result in the denial of minorities' right to vote. Congress was intent on stopping this more subtle form of discrimination. Yet, in what only can only be described as a usurpation of Congress' constitutionally assigned legislative role, the court in Burdic announced several new guideposts, seemingly from whole cloth, that lower courts are to consider in evaluating vote denial claims under Section 2's results test. When evaluating claims under these new factors, lower courts could narrow plaintiffs' ability to challenge discriminatory yet facially neutral voting practices, the very practices that Congress broadened the scope of Section 2 to confront. None of these new guideposts have a basis in the text or legislative history of Section 2. Instead, they appear to reflect what the Burdic majority thinks the scope of Section 2 ought to be, not what Congress actually intended the scope to be when it amended the statute in 1982. As I've already noted, Congress passed the current version of Section 2 in response to an earlier Supreme Court decision that narrowed Section 2's scope. Today, 40 years later, Congress again finds itself in the position of having to consider how to clarify the scope of Section 2 to ensure that broad voting rights protections remain in place. The circumstances Congress faces today, however, appear far more dire. The Brnovich decision has come in the midst of a new wave of racially discriminatory voting rights laws across the country, which itself is a result of the court's disastrous 2013 decision in Shelby County versus Holder, which gutted the VRA's Section 5 preclearance regime. As many of you know, dozens of Texas lawmakers are in Washington now in a brave attempt to prevent the Texas legislature from jamming through a harsh new voter suppression law. Similar efforts to restrict voting are underway in state legislatures throughout the country. Congress must ensure that federal protections are in place to block such discriminatory laws. In her dissent to the Brnovich opinion, Justice Kagan properly raised the alarm. She wrote, "The Voting Rights Act of 1965 is an extraordinary law. Rarely has a statute required so much sacrifice to ensure its passage. Never has a statute done more to advance the nation's highest ideals, and few laws are more vital in the current moment. Yet, in the last decade, this court has treated no statute worse." I could not agree more. Congress must act where the court has failed voters across the country. I thank Chairman Cohen for holding today's hearing, and I look forward to the testimony of our witnesses. And with that, I yield back the balance of my time.
Thank you, Mr. Chairman. It is my understanding that the ranking member of the full committee, the gentleman from Ohio, Mr. Jordan, does not have an opening statement. If I'm wrong, he's welcome to present it at this point.
No, thank you, Mr. Chairman. I associate myself with the remarks of Ms. Fishbach and look forward to the hearing. Thank you for this and look forward to hearing from our witnesses.
Thank you, Mr. Jordan. We welcome our witnesses and thank them for participating in today's hearing. I will now introduce each of the witnesses, and after each introduction, we'll recognize that witness for his or her oral testimony. I do this a little differently. I give the introduction before they testify so you can kind of have it in your mind rather than doing them all at once. Each of your written statements will be entered into the record in its entirety. Accordingly, I ask you to summarize your testimony in 5 minutes. To help you stay within that frame, there's a timer in the Zoom view that should be visible on your screen. Before proceeding with the testimony, I remind all of our witnesses you have a legal obligation to provide truthful testimony and answers to the subcommittee. Any false statement you make today may be subject to prosecution under Section 1001 of Title 18 of the U.S. Code. Our first witness is Sean Morales Doyle. Mr. Morales Doyle is acting director of the Democracy Program at the Brennan Center for Justice at the New York University School of Law, where he focuses on voting rights and elections. He advocates for pro-voter reforms like automatic voter registration and voting rights restoration while fighting back against voter suppression efforts in the courts. Prior to joining the Brennan Center, Mr. Morales Doyle practiced law in Chicago, where he litigated all manners of civil rights and constitutional matters, and I'm sure he had broad shoulders. Mr. Morales Doyle earned both his undergraduate and law degrees from Northwestern University. He served as a law clerk to the Honorable William J. Hibbler of the U.S. District Court for the Northern District of Illinois. Mr. Morales Doyle, you are recognized for 5 minutes.
Thank you, Chairman Cohen, Ranking Member Johnson, members of the committee. Thank you for the opportunity to testify before you today about the Supreme Court's recent decision and how Congress should respond. We are witnessing a wave of restrictive voting laws more significant than we have seen since the voting rights was signed into law. And while the Supreme Court's 2013 Shelby County decision helped open the floodgates to these efforts to roll back voting rights, The Burdic decision weakened one of the tools we might otherwise use to stem the tide. So Congress must once again meet this moment, as it has in the past, in 1965 and in 1982, to protect voters from discrimination. To provide truly comprehensive protection, Congress must restore the Voting Rights Act to its former glory and pass the For the People Act to set a new standard for elections free from discrimination. I will start with a brief explanation of the harm the Burdic decision does, and then turn to potential remedies. The first mistake of the Burdic majority is that it departs from decades of precedent and shifts the focus of its analysis away from what Congress intended, which was an evaluation of how voting rules interact with the effects of race discrimination. That is the purpose of the Totality of the Circumstances test in Section 2. But the court shifts its focus to a set of 5 so-called guideposts for courts to consider moving forward. In my written testimony, I explain in detail how each of these guideposts will lead courts astray from the cause of identifying and rooting out discrimination in voting. The short version is that they direct courts to view with skepticism characteristics that are in reality the hallmarks of modern-day vote suppression. The reality is that state legislatures are not hacking, but slicing away at voting rights from every angle. They shave away access to mail voting. They cut back on in-person voting. They trim voters from the rolls through faulty purges. While any one slice might appear minor, the end result is death by 1,000 cuts. This is how states, in the words of the Fourth Circuit Court of Appeals, target voters of color with almost surgical precision. But the majority in Burdic seems willing to accept discriminatory burdens so long as they do not deny the right to vote to too many. The majority doubts a restriction on one method of voting discriminates if there are other methods available. If a state's voting laws are better than the status quo in 1982, the majority suggests it will be hard-pressed to find them discriminatory. What's worse, the majority is far too quick to accept the excuse states give for these discriminatory laws in each and every instance, fighting fraud. The court accepts at face value the lie that currently threatens to undermine our democracy. My colleagues and I make it our mission to defend the right to vote. This decision, following on Shelby County and others, leaves us facing unprecedented attacks with a blunted tool for fighting back. So what's the solution? To remedy the harm done by Shelby County, Congress should restore preclearance by passing the John Lewis Voting Rights Advancement Act. But now, to truly restore our power to push back on discriminatory laws, Congress must strengthen Section 2. First, Congress must ensure that the court's wrong-headed guideposts won't prevent the identification of truly discriminatory practices. Congress could spell out the considerations that are relevant to determining whether a rule produces discriminatory results, making explicit the central role that historical and current discrimination must play in the court's analysis of Section 2 claims. The Senate factors helped guide the courts for decades, but Congress could also elaborate upon them. Second, Congress must make clear that the true threat to our democracy is race discrimination, not widespread voter fraud. In order to right-size deference to states, Congress could require courts to consider the tenuousness of the relationship between the policy at issue and the stated goal. Or it could require states to prove that the rule in question actually serves the goal. Finally, it is critical that Congress make explicit that there is no tolerable level of race discrimination. With these goals in mind, Congress can remedy the harm done to the Voting Rights Act. But restoring the Voting Rights Act is not enough. Congress must also pass the For the People Act and create a new national standard for voting. This will take some common tactics for restricting voting off of the table. We applaud the House for doing its part on this already. Thank you again for the opportunity to contribute to this conversation.
Thank you, Mr. Morales Doyle. We appreciate your work and your testimony. Our next witness is Nicholas Stephanopoulos. Mr. Stephanopoulos is Kirkland and Ellis Professor of Law at Harvard Law School, where he teaches classes on election law and constitutional law, the future of voting rights, and workshops on law and politics and on voting rights litigation and advocacy. Prior to joining the Harvard faculty, Professor Stephanopoulos taught at the University of Chicago Law School and Columbia Law School. And before that, he was in private practice. Professor Stephanopoulos received his JD from Yale Law School, his Master of Philosophy from the University of Cambridge, and his A.B. in Government summa cum laude from Harvard University. He also served as a law clerk for the Honorable Raymond C. Fisher of the United States Court of Appeals for the Ninth Circuit. Quite an impressive resume. Professor Stephanopoulos, you're recognized for 5 minutes.
Thank you, Chair Cohen, Ranking Member Johnson, and distinguished members of the committee for inviting me to testify today. As the chair mentioned, I'm a professor at Harvard Law School, where I specialize in election law. Much of my work over the years has involved the Voting Rights Act. And most relevant here, I wrote a 2019 article called Disparate Impact Unified Law, in which I proposed a standard for vote denial claims under Section 2 of the Act. Several justices asked about my proposal at the Brnovich oral argument, and the court's decision also cited my article. I'd like to make 3 points about that decision in my testimony today. The first is that it's indefensible as a matter of ordinary statutory interpretation. The justices in the Brnovich majority claim to be textualists. When reading a statute, they claim that they start with the text and they end with the text. But the factors the court announced for future Section 2 cases are simply unmoored from the statute's language. You can stare at that language for as long as you want, but you'll never find any references to the size of a voting burden or the size of a racial disparity, let alone what policies happened to be in place back in 1982. The court's only defense for its extra textual factors is that Section 2 mentions the, quote, totality of circumstances. That phrase supposedly authorizes the justices to invent whatever criteria they think are appropriate. But the totality of circumstances isn't an invitation to the justices to become our platonic guardians. It's just a reference to the factors listed in the 1982 Senate report. As Justice Kennedy once wrote, quote, for this purpose of interpreting the totality of circumstances, the court has referred to the Senate report on the 1982 amendments. Until now, the court hasn't relied on its own idiosyncratic judgment. Bad textualism is bad enough. My second point, though, is that the court's flawed reading of Section 2 will seriously impair efforts to fight racial discrimination in voting. This is because each of the court's factors is designed to make it harder for Section 2 plaintiffs to win their cases. Each factor puts a thumb on the scale in favor of defendants. Together, the factors amount to a roadmap showing states how to avoid liability for the racial inequities of their elections. Take the factor about the state of the world in 1982. In that era, early and mail-in voting were strictly limited. Innovations like automatic voter registration and ballot drop-off boxes were unknown. So under the court's approach, cutbacks to those policies would likely be fine. No matter what racial disparities the cutbacks caused, at worst, they would just return states to the 1982 status quo. Fortunately, Congress doesn't have to accept the shackles the court attached to Section 2. Brnovich is just a decision construing a federal statute. If Congress disagrees with the decision, it can and it should override the court. And that's the last point I want to make today. In particular, I'd recommend the insertion of 2 new paragraphs into Section 2. And let me flag that my written testimony includes potential language for these provisions. The first new paragraph would list the court's factors and then state that they're not among the circumstances that should be considered in Section 2 cases. The second new paragraph would say that the approach Justice Kagan described in her dissent is part of the totality of circumstances. Under that approach, there are 2 critical issues. First, does an electoral practice result in a statistically significant racial disparity? And second, is the practice necessary, the least restrictive means to achieve an important state interest? Something like Justice Kagan's test is already used under Title VII and the Fair Housing Act. Justice Kagan's test is also constitutional, given that the rest of disparate impact law is valid. Most importantly, Justice Kagan's test is effective. Many electoral rules cause significant and unnecessary racial disparities. More such rules are currently being debated around the country. All these policies would be caught by Justice Kagan's test. So therefore, Congress ought to embrace that test and move us closer to a world where our elections are finally free of racial inequities. Thank you very much. I look forward to your questions.
Thank you, Professor. Our third witness is Robert Popper. Mr. Popper is a senior attorney and director of voting integrity efforts at Judicial Watch Incorporated, where he has been an employee since 2013 and has litigated several voting rights cases. He's been practicing as a litigator for 31 years with special knowledge and expertise in the areas of voting law. In 2005, he joined the voting section of the Civil Rights Division of the U.S. Department of Justice, where he worked for 8 years, earning a Special Commendation Award for his efforts in enforcing National Voter Registration Act of 1993. He was also promoted to Deputy Chief of the voting section. In his time at the DOJ, he managed voting rights investigations, litigation, consent decrees, and settlements in dozens of states, including those concerning the Voting Rights Act of '65. Mr. Popper received his JD from Northwestern University School of Law and his undergraduate degree from the University of Pennsylvania. Mr. Popper, you're recognized for 5 minutes.
Thank you, Chairman Cohen, Ranking Member Johnson, and members of the subcommittee. In my view, the Brnovich decision relied heavily on the plain text of Section 2, which the chairman read at the beginning of this hearing. The court analyzed the words open and equally open using dictionary assistance, and it analyzed the text holistically in the context of the additional phrase, and that open and equally open meant in that the members of a group have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. The court's decision was not unexpected and had been presaged by a majority of circuit courts to have considered this issue. Remember, there has been a long unresolved legal problem as to how to apply Section 2 of the Voting Rights Act to time, place, and manner restrictions. Numerous courts over the years have commented on how the Jingles criteria are an uncomfortable fit for vote denial cases. And that guidance was something that the court provided. I wanted to note that we've discussed already the 5 guideposts that the court identified. And it is important to realize that the court called them a non-exhaustive list of factors to consider in looking at the totality of the circumstances. Now, bear in mind that the original Senate factors that we all know and work with was a non-exhaustive list. I'm quoting now from the 1982 report from which the Senate factors where they were first enumerated. And the report says typical factors include, and it lists the 9 factors. And then it says, while these enumerated factors will often be the most relevant ones, in some cases, other factors will be indicative of the alleged dilutions. That raises another point. The language in Section 2 came from White versus Register in 1973. That was a multi-member district case. Jingles was a multi-member district case. From the beginning, Section 2 has been targeted to vote dilution and districting, multi-member district, at-large districts kinds of cases. As I indicated, as I said, courts have routinely commented on how there's no guidance as to how to treat a time, place, and manner restriction. Now, because it was unresolved, there has been a rash of lawsuits that I would say were of poor quality and should not have been brought. In my written testimony, I discussed the Ohio Democratic Party versus Houston from 2016. Bear in mind that the alleged Section 2 violation that the trial court found to have occurred was that Ohio cut its early voting days from 35 days to 29 days. Bear in mind as well that as we sit here, Connecticut and Delaware have no early voting. So it's not that you're going to get sued for whether or not you have early voting. You're going to get sued if you have it and then repeal it. That makes no sense. Now, I would add that some very famous politicians, including the President of the United States, have invoked Jim Crow. That is, in my view, an outrageous thing to say. At its worst, Jim Crow involved state government officials colluding with domestic terrorists to murder American citizens. Even if you look at the voting angle of Jim Crow, it involved literacy tests that were 6 pages long, and no one, I respectfully submit, on this committee could pass. It involved all white primaries that determined the winner. It was shocking in its extent, but it has nothing to do with 35 days to 29 days of early voting. It has nothing to do with no out of precinct voting, as in Arizona, for some counties, not all. It has nothing to do with saying that mail ballots after COVID have to be collected by a family member, household member, or caregiver. We need some perspective in this debate. We need to understand what's happening. I can go on at length, although not according to the clock, but I can talk about the Texas and the Georgia legislation as well. And by the way, both Texas and Georgia, unlike Connecticut and Delaware, have early voting. Thank you, Mr. Chairman.
You're welcome, Mr. Popper, and we thank you for your testimony. Our final witness is Ezra Rosenberg. Mr. Rosenberg is co-director of the Voting Rights Project and Lawyers Committee of Civil Rights under the law. Under that role, he supervises the Lawyers Committee's National Voting Rights litigation. He joined the Lawyers Committee in November 2014, continuing a 40-year career in the public and private sectors. Previously, he practiced at a major national firm where he was actively involved in pro bono representation, including successfully challenging Texas's photo ID voting law. He was also one of the lead trial counsel in the case challenging the Secretary of Commerce's decision to add a citizenship question to the 2020 census. Mr. Rosenberg received his JD cum laude and orders of whatever from the NYU School of Law and his BA cum laude from the University of Pennsylvania. Mr. Rosenberg, you're recognized for 5 minutes.
Thank you, Chairman Cohen, today's ranking member Fishback and members, and thank you for giving me the opportunity to testify today on these important issues. Racial discrimination in voting diminishes our democracy. The Voting Rights Act of 1965, and particularly Sections 2 and 5, has been an indispensable tool in the fight against such discrimination. With the evisceration of Section 5 by the Supreme Court in Shelby, Section 2 is needed more than ever. For decades, Section 2 has been working quite well. The courts have developed standards designed to meet the intent of Congress to stop not only explicit discrimination, but also facially neutral voting laws that through subtle methods had a significant impact on minority citizens' right to vote. Thus, the courts adopted standards that recognize that a seemingly innocuous voting practice can interact with underlying social conditions, themselves the consequence of discrimination, to result in pernicious discrimination in voting. Those standards were judicially manageable. There's been no flood of questionable Section 2 vote denial cases, no widespread invalidation of voting regulations. Indeed, Brnovich marked the first time since the 1982 amendments to the Voting Rights Act that the Supreme Court reviewed a pure vote denial claim. But in Brnovich, writing for the court's majority, Justice Alito provided guidelines for future treatment of Section 2 vote denial cases that were not only new, but also contrary or at least dilutive of the decades-long accepted standards. Now, I emphasize that Brnovich does not spell the end of Section 2 cases, but it unnecessarily and unreasonably makes it much more difficult for civil rights plaintiffs to win those cases, particularly results cases, when they already were difficult to win. And it does so in a way that flies in the face of congressional intent. Further, it raises too many ambiguities in too many important areas to leave it to the courts to fill in the blanks. I come to these views after having devoted the bulk of the last decade litigating voting rights cases on behalf of the voters of color for the Lawyers Committee. The Lawyers Committee is a national civil rights organization created at the request of President Kennedy in 1963 to mobilize the private bar to confront issues of racial discrimination pro bono. In fact, I first became associated with the Lawyers Committee in 2011 when I was in private practice and volunteered to take on a voting rights case pro bono, and that case was the challenge to Texas's strict photo ID law. My experience with that case heavily influences my views here today. There, we and other groups successfully sued under Section 2, and Texas was forced to change its law after the Fifth Circuit ruled en banc that Texas's photo ID law discriminated against Black and Latino voters. But the case was hard fought, took 6 years to litigate. It's difficult to predict how the Fifth Circuit would have applied Burdic to the facts of the Texas case, but one thing is certain, the case would have been much more difficult to prove and more costly to litigate. There are at least two approaches that Congress can take in response to the Shelby County Brnovich assault on the Voting Rights Act. The first is to pass legislation like the John Lewis Voting Rights Advancement Act that addresses the hole in the Voting Rights Act left by the Shelby County decision. The second is to deal with the expected consequences of Brnovich. Common sense and history instruct us that those who wish to target voters of color will undoubtedly feel emboldened by a decision that can be read as making it more difficult for plaintiffs to prove a Section 2 violation and read it as a signal that they have a get out of jail card to pass additional voter suppressive legislation. Although we firmly believe that the court should not apply Brnovich in such manner, the threat is there. Continued commitment to the core purpose of the Voting Rights Act should not be left to the uncertainty created by the ambiguous and problematic language of Brnovich. I'm going to end with the same quote that Chairman Nadler used from Justice Kagan's dissent. We must share the same speechwriter, but it is important language. The Voting Rights Act of 1965 is an extraordinary law. Rarely has a statute required so much sacrifice to ensure its passage. Never has a statute done more to advance the nation's ideals, and few laws are more vital in the current moment. Thank you.
Thank you, Professor Rosenberg. I will now recognize myself under the 5-minute rule and proceed with question. Professor Stephanopoulos, the Brnovich majority is, in my opinion, and I'd like to know your opinion, activist and not textual. Would you agree with describing their opinion as an activist decision?
Thank you, Chair Cohen, for that question. Yes, I would absolutely agree with that assessment. There's a real irony in the current court's conservative self-description as modest, restrained textualists, when every line of Brnovich, you can read the insertion of the court's own conservative ideology. The 5 factors, as we've discussed, are plucked out of thin air. They're not rooted in the actual language of Section 2. Every one of them reflects the court's hostility to the mission of the Voting Rights Act, which is ending racial inequities in American elections.
In some ways, I think of it as being analogous to Plessy v. Ferguson. Plessy was after we had ended Reconstruction with the 76 Hayes-Tilden agreement that was the pox on both political parties, the court, Plessy v. Ferguson, said separate but equal. Is this kind of like that in a way, Professor Stephanopoulos, and that they're saying that if it affects certain voters similar to majority voters, and if they have some problems and the minority has some problems, and it's kind of like not much of a discrimination, that it's okay?
Well, that's a fairly inflammatory analogy, and I
yes.
don't.
And I don't, and you're not.
I wouldn't say that the current measures are, really the equivalent of Jim Crow. I think they're more fairly described as Jim Crow light as opposed to Jim Crow 2. The intent and the massive racial disparities of the real Jim Crow era, I don't think are present here. But nevertheless, we have a host of nominally neutral restrictions of voting that one after another end up causing predictable and substantial racial disparities. These aren't the huge racial disparities of the late 19th century or the early 20th century, which is why I don't think that this is a Jim Crow 2.0 era. But we do see a proliferation of measures that do in fact disproportionately and unnecessarily make it harder for minority citizens to vote.
Do you agree with Professor Rosenberg that this is basically a canary in the coal mine and it portends future in cases being interpreted, construed in the same manner?
I would say it's more than a canary in a coal mine. This is the coal mine itself on fire. This isn't a portent of bad things that might happen in the future. This is the bad things happening right now.
And if there are these problems that we can foresee coming as the VRA is eroded, Congress needs to act to amend the court rules. Do you have any suggestions on what we need to do in amending the law?
Yeah, I would recommend following the path that Justice Kagan laid out in her dissent, which is to say that two factors above all are critical in Section 2 vote denial cases. Those are, number one, does some regulation of voting cause a statistically significant racial disparity? And if so, number two, is that practice really necessary to achieve some important state interest? Not all neutral voting regulations would fail under this test, not by a long shot, but some would. The ones that are producing large inequities that can't be justified, those practices would properly be eradicated. That's exactly what the VRA was meant to accomplish.
Professor Rosenberg, one relevant consideration that the court's majority read into Section 2 is the degree to which a voting rule departs from what was standard practice when Section 2 was amended in 1982. Do you think Congress intended the year 1982 to remain the standard by which burdens placed on minority voters by present-day voting practices should be forever compared? Was that a time that we just froze in history and there'll be no improvements, no changes, no more progress? It's just basically 1982.
Thank you. I assume that was addressed to me, Chairman Cohen. I am not a professor as much as I would like to be. Professor Stephanopoulos is colleague. Justice Alito, in his opinion, where he set 1982 as what he called a benchmark for against which to compare present-day discrimination, just doesn't make sense. And not only doesn't make sense, but Justice Alito never explained why. In response to Justice Kagan's dissent, he simply said, well, it's useful. It's useful because it's useful. And that tautology just doesn't really do the job. As Justice Kagan said in her dissent, Section 2 is intended to eradicate discrimination, not to set it in amber. And that's precisely what using a 1982 benchmark does. If one thing we've been taught by history, it's that those who want to discriminate on the basis of race in voting, they change with the times. When, at one time, of course, only white people were allowed to vote. And after that it was declared unconstitutional in the 15th Amendment. Different means were used by those people. They changed with the times, poll taxes, literacy tests. And after those were rendered unconstitutional, they changed with the time, closing polling locations, complicated registration systems, voter ID laws that they knew would affect Black and Latino voters much more severely than it would affect white voters. And history also teaches us that those who would discriminate against people of color in their voting will change as those voters of color change the way they vote. So now we have voters of color using absentee ballots in places like Georgia more at a greater rate than do white voters. And what happens? All of a sudden, the Georgia legislature decides it's going to start clamping down and adding unnecessary and burdensome restrictions on absentee ballots. States cannot be led to believe that they can get away with voter suppressive legislation by pointing to what happened 40 years ago.
Thank you, Mr. Rosenberg. That concludes, plus a little bit of extra of my time. And I now recognize Ms. Fischbach for 5 minutes or a little more.
And Mr. Chair, I would just ask, Ranking Member Johnson has joined us, and I would defer to him if he had questions before me.
I do. I thank you so much. And thank you for filling in today. I apologize for being late to the hearing. I just attended a funeral of a fallen law enforcement officer in my district, and it's quite a sad occasion. I thank the witnesses for being here. I have questions for Mr. Popper. Let me just start and say, one of the laws in question in the Brnovich case requires voters to vote in their own precinct. And in your estimation, I'm wondering if you could tell us how widespread is this requirement across the country, and specifically, is it only limited to states with Republican majority legislatures?
I'm sorry for your loss and for your state's loss. It most definitely is not. And, I wanted to touch on something that Mr. Rosenberg, I almost said Professor Rosenberg, touched on. And that is that when you have a voting rule that has a disparate impact, even by a tiny fraction, you can construct a case on that, prior to Brnovich at least, in which you say, we'll take that tiny difference and we'll call that a disparate impact. And we will look at historical conditions having nothing to do with voting in many cases. And we'll say that there's a Section 2 violation. That was the old rubric. That's how you get to sue over what are ordinary regulations. Now, what the Supreme Court identified was the trick that's being played. Out of precinct voting is used by 1% of minority voters. And that means that 99% vote in the right precinct. Out of precinct voting is used by 99.5% of non-minority voters. And this is in Arizona, and this is in the decision. So in other words, 99% minority, 99.5% non-minority. Well, what do you conclude from that? Minority voters vote out of precinct at twice the rate of non-minority voters. It's technically true. But the difference between 99 and 99.5 is not something that people should sit up and take notice about. It is fair as a part of a totality of the circumstances analysis to say that in the totality of the circumstances, that difference is not appreciable enough. And I would also add that every court paid lip service to the idea. And in many cases, it was just lip service. But they said that while all courts, that disparate impact is not enough to make a Section 2 claim. You need more. You need some sort of showing. You need some sort of Senate factor evidence, and it had always been unclear what you needed for vote denial. Well, while saying that, Arizona is a pure disparate impact case when it comes to out-of-precinct voting. The difference between 99.5 and 99% was enough to get you a violation, and that's what was reversed by the Supreme Court. But, you know, many other ordinary seeming restrictions, for example, straight ticket voting, that's only allowed in 6 states. 6 states. So a state can be sued for trying to restrict straight precinct voting or straight ticket voting. You know, procedures and provisions that have vast majority usage throughout the United States are subject to Section 2 claim, particularly if they've been passed and then there's an attempt to repeal them. And Congressman, before you joined us, I had pointed out that both Texas and Georgia have early voting, and Connecticut and Delaware do not. Now, a perverse incentive of the pre-Brnovich jurisprudence is that it would behoove Connecticut and Delaware never to pass early voting, because if they do, they will always be subject to a Section 2 claim if they try to repeal it.
Well, and let me just say on the earlier issue, speaking of Connecticut and Delaware, if I'm correct me if I'm wrong, at least 25 states do not count ballots cast in the wrong precinct. And that includes Connecticut, Vermont, Delaware, and Hawaii. So it's not just Republican jurisdictions, of course. This is a widespread understanding. We're running out of time. Let me ask you real quick. Would you agree that the Brnovich decision effectively at least begins to put a stop to partisans using courts to throw out policy decisions they simply disagree with?
It certainly does. And as I explained in my testimony, there was a majority decision. And while we were sitting here, I identified 9 courts of appeals that would have ruled basically as the Supreme Court did in Brnovich. 9, or decisions. I'm sorry, some of them are double from the same court. And it was this minority decision that was allowing these kinds of, in my view, outrageous claims to proceed against what are very ordinary rules based on the tiniest discrepancies.
I don't have the clock, Mr. Chairman, so stop me. But if I have time for one more question.
Your time has expired, sir.
All right. I yield back. Thank you. Appreciate the accommodation.
You are legislating while driving.
I parked.
All right, good. Thank you. Next is Mr. Nab.
Thank you, Mr. Chairman. Mr. Morales-Doyle, in the Brnovich majority's view, one relevant factor courts should consider when evaluating Section 2 vote denial claims is the legitimate state interest justifying the challenged voting rule. The court has observed that rules that are supported by strong state interests are less likely to violate Section 2. The court then pointedly noted that one strong and entirely legitimate state interest is the prevention of fraud. We all agree that preventing fraud is a legitimate state interest, but we're now living in the age of the big lie, and there is no evidence that widespread voting fraud is a significant problem that affects the outcome of elections. Meanwhile, state after state is enacting discriminatory voting practices in the name of election integrity protection. Are you concerned that this state interest factor opens the door to a lower court upholding a facially neutral yet discriminatory voting practice without even requiring the state to show evidence of widespread voting fraud?
Yes, I am concerned about the way lower courts will apply this guidepost. The fact is that the Senate factors and the test that's been applied for years under Section 2 already took account of state interests. It asked courts to look at whether the connection between the state interest offered up and the policy in question was tenuous or not. And if it were tenuous, then a court might look more skeptically at the policy in question. Courts have always taken state interest into account. What is troubling about the majority's opinion is how quick the court is to accept the idea that these policies are actually rooting out fraud and necessary to do so, when actually we have states, including Arizona, are extremely effective at stopping fraud already. That is why we don't see widespread voter fraud. The Federal Cyber and Infrastructure Security Agency said the 2020 election was the most secure election in American history. This just isn't a problem that needs fixing. And so courts should be skeptical when disparate burdens are being placed on voters of color to pursue it.
Thank you. Now, Justice Kagan's dissent notes that a state is not even required to demonstrate that a challenge practice is the least restrictive means for the state to achieve its interest. Can you explain why this is so problematic?
Right. So as I said, most states are already effectively stopping fraud. And so the idea that states need to add more and more restrictive rules on top of what they already have in order to accomplish that goal is just not true. And so what Justice Kagan would say is, if you say that you're preventing fraud, but there's a way to do it that doesn't stop people of color from voting, that doesn't impose a disparate burden on people of color, then you should go that route. And frankly, that route in many instances would be leave things as they are, keep the status quo. We're doing a great job of stopping fraud. But under the majority's opinion, you can say fraud, and unfortunately, they're giving courts a lot of room to run with that excuse and allow discriminatory burdens to persist.
Is there any textual basis or legislative history that supports the court reading this so-called guidepost into Section 2?
No, I think the Senate factors from Congress made clear that they did want to take state interest into account, but nothing in the legislative history or in the text suggests that the court should be so deferential to state interest that they allow claims of fraud or claims of fighting fraud to trump the goal of rooting out discrimination. The point of Section 2 is to eradicate race discrimination in voting.
Thank you. Mr. Rosenberg, in 1982, Congress amended Section 2A of the Voting Rights Act and added Section 2B to reverse the Supreme Court's decision in City of Mobile versus Bolden, which had interpreted the previous version of Section 2 to prohibit only intentionally discriminatory voting rules. How did courts previously interpret this legislative history up until the Supreme Court's decision in Brnovich? And how is the Brnovich decision a significant departure from the court's previous understanding of this history?
Oh, in every which way, Chairman Nadler. The focus of the post-1982 amendment was on effects, irrespective of state justification. Results, effects, that was what the 1982 amendment was all about. And what the Brnovich decision does is not only veer from there, but it veers from the totality of the circumstances a standard that was put into the statute at that time. And the focus, as the court in Jingles interpreted that, and it was applied consistently on the interaction between the challenged conduct and historical, social, and economic discrimination. And that is not even mentioned by Justice Alito when he goes through his various guideposts. He doesn't talk about that key factor of the interaction between the challenged conduct and the effects of historical discrimination.
Thank you. I see that my time has expired. I yield back.
Thank you, Mr. Nadler. Now comes one of those moments when the chairman has to make a great decision. Should he recognize Mr. Jordan, who is next in line to Mr. Johnson, or should he go back to Ms. Fishbach, who was so nice as to yield her time to Mr. Johnson?
Go to
Mr. Jordan, I'll leave the decision.
I thank you, Mr. Chairman. Go to Ms. Fishbach, and I'll wait till the next round.
Thank you,
Thank
sir. Fishbach, you're on.
Well, thank you, Mr. Chair, and thank you, Mr. Jordan. I appreciate you deferring to me. And I've got a question for Mr. Popper. You know, Justice Alito identified a non-exhaustive list of circumstances for courts to consider as part of the totality of the circumstances review. And I think you touched on it a little bit in your testimony. You know, one of those circumstances is the size of the burden imposed by the voting rule. Justice Alito did note that mere inconvenience is insufficient, and an equally open voting system must tolerate the usual burdens of voting. Can you expand a little bit on what that means?
Well, yes, and it's in many ways, thank you for your question. I'm sorry, I was organizing something else. In many ways, it is an application of what we call the Anderson-Burdic test. I mean, where you have an administrative burden to a civil right or to voting, you assess the importance of the state interest, and you assess how much of an inconvenience it is. And if it's a severe inconvenience, that's one thing. But if it's not, and another point that the court mentions, if there are other ways for you to get done what you need to get done as a voter, you have to take that into account. You have to be practical about this. I think that in a way, or perhaps directly, what the court was doing was combating the rash or what it called a proliferation of lawsuits of little merit that had sprung up, the cottage industry of challenging any restriction of early voting, any restriction of registration or same-day registration, any restriction of voting in precinct, particularly if you've once passed the law one way and you're looking to put it back the other way. I mean, I would refer to the atmosphere in Texas. In Texas, consider, the law that they're fleeing to avoid passing provides a free voter ID to anyone who doesn't already have one. What you have to do in order to identify your absentee ballot is put the number of the voter's driver's license, or the number of their free ID, or the last four social, or certify that you don't have these numbers. In Texas, you also, they provide an opportunity for voters using absentee ballots who did it wrong to go back and correct a defect in their ballot so it's not tossed. And you sure don't see that covered in the newspapers, but it's in the statute. They require an assister, someone who gives assistance, to give their name. Now in California, it can be anyone knocking on your door. It can be, they don't have to say where they're from. They don't have to give their first name, their last name, their real name. They don't have to register. You will never discover, once you receive the ballot in California, that it was collected, okay? This merely asks the person to put down their name. What is so shameful about that? That's the atmosphere in Texas. In Georgia, the atmosphere is that you get 3 weeks of early voting. You still get no excuses absentee ballot. You still get that. In other words, any reason you can have such a ballot. Voters have to submit a state ID number. It does away with signature matching on mail ballots, but signature matching on mail ballots had long been considered problematic, and it was, unclear that it favored one side or the other. It was just hard to tell a bunch of untrained poll workers how to make that assessment. That's the atmosphere in Georgia. Voting is easy in Ohio. It is easy in Arizona. Frankly, it's easy in most of the country. So I think I may have strayed from your question. I apologize.
Well, and maybe we've just got a couple of seconds left here, but I would just like to kind of follow up and maybe ask you, what is a usual burden of voting? As they use that term.
Well, as they said in Crawford, you have to get in your car and go vote. It's not a usual burden to get in your car and drive for 3 hours. And there's lawsuits about that. And it's not a usual burden, but it is a usual burden to, have to show up in person. You can't say, COVID to one side, COVID style elections to one side. You can't say that imposes a terrible burden. And I would add too, that what was appropriate for COVID may no longer be appropriate. And repealing the COVID related absentee rules isn't discrimination.
Thank you very much. And I am out of time. And Mr. Chair, I yield back.
Thank you. I appreciate it. Next person will be Congressman Professor Mr. Raskin.
Mr. Chairman, thank you very much. Thanks to all the witnesses for your testimony. Our colleague, Representative Fishback, started by saying that she didn't know anyone who wants to stop people from voting, but even Mr. Popper referred to the history of Jim Crow and the vicious disenfranchisement that took place then. And of course, we all know about the history of grandfather tests and poll taxes and literacy tests and character tests and so on. Professor Stephanopoulos, let me start with you. Do you agree with Ms. Fishbach's suggestion that the determination to keep people from voting ended at some point, say between the 1960s and 70s and today, or does that history continue right up till today?
I think that history, unfortunately, continues. I think that when politicians regulate the electoral process, they're highly, highly aware of what the likely composition of the electorate is going to be as a result of their regulations. They're also highly, highly aware of which voters are likely to support their party and their candidates and which voters are likely to oppose them.
Well, let me ask you about that if I could. If there is a determination to keep, say, African Americans from voting or Latino voters from voting, not out of racial animosity, but because of a fair prediction that they will disproportionately support the other party, is that itself race discrimination within the meaning of the Voting Rights Act?
Well, whether or not it's a discriminatory racial intent, it absolutely is a disparate racial impact if the effect of that regulation is to deny the vote to a larger proportion of African American or Latino or Asian American citizens. I think it's complicated when the true motivation is partisan, whether one can also label that as invidious racial intent.
Mr. Rosenberg, let me come to you. The striking thing to me today is that voter fraud is the slogan of people trying to commit voter fraud. One great example of that is Donald Trump's famous hour-long phone call with the Republican Secretary of State of Georgia, Brad Raffensperger, in which he twisted his arm, he needled him, he begged him, he tried to coerce him into finding just 11,780 votes. That's all he was looking for. And all of this was done publicly in the name of preventing fraud, preventing voter fraud against him. He was claiming in his big lie that the election was being stolen from him while he was trying openly to commit voter fraud by getting an election official to manufacture and concoct votes that didn't exist. So what is the public supposed to do when people who are trying to commit voter fraud are invoking voter fraud as the reason for their disenfranchisement and voter suppression schemes?
Now, invoking fraud prevention has been used historically to justify discriminatory practices for well over a century. It was used to justify poll taxes. It was used to justify literacy tests. It was used to justify early poll closings, and then it was transmogrified into this feeling that, the public is demanding action because they have concerns about election integrity. But what happened is that the people who are purveying this myth of voter fraud are fabricating the justification. They're fabricating the results of the surveys because they're the ones who are out there telling the people that there's fraud when there's not fraud. And then they survey the people and the people say, oh, we have concerns because there's voter fraud. And then they use those basically false survey results to justify the voter suppressive legislation.
Thank you. Thank you. Professor Stephanopoulos, let me come back to you. You pointed out that the Brnovich decision is not a constitutional decision. It's a question of statutory interpretation. You're saying that Congress could override the invention of these 5 guideposts or signposts that were pulled out of a hat by Justice Alito, which we definitely could. Has the Congress had success before in reversing reactionary decisions by the Supreme Court giving pinched or erroneous interpretations of civil rights statutes by rewriting those statutes, or does the court keep on, moving the football at every point?
Yes, Congress absolutely has had luck doing that, not just with respect to the Voting Rights Act, but also with respect to the Civil Rights Act. So Section 2's Amendment 1982 is a great example of Congress stepping in to reverse a mistaken court decision. And so is Congress's amendment of the Civil Rights Act of Title VII to reverse a Supreme Court decision that overly narrowed the disparate impact theory under Title VII of the Civil Rights Act.
I appreciate that. My time is up, Mr. Chairman. I yield back to you.
Thank you, Mr. Raskin, and we will now yield to Mr. Jordan for 5 minutes.
Thank you, Mr. Chairman. I would just come to Mr. Popper. I think in your opening statement, you said there were a couple other states you wanted to highlight, and frankly didn't have the time in your 5 minutes, which I understand. We always run out of time in these hearings. So I was just going to give you a chance to talk about. I think one of the states you mentioned was Texas. I actually forget the other state that you may have referenced, but give you a few minutes to talk about those states and what's happening there and how it relates to our subject matter.
Thank you, Congressman. I think I did speak about them. I managed to sneak them in somewhere, but
Okay.
I was merely making the point. I thought that in Texas, the atmosphere is so loaded in favor of getting people to the polls. And it is in Georgia too. And these two bills, I find almost universally that the people who are the angriest about them, and I don't include anyone on this committee, I'm just saying that in other conversations, there are people who haven't read this legislation.
If I could, Mr. Popper, just my understanding is in both states, there was already great access. I mean, amazing access for people to vote, which is what we want. We want to make it easy to vote, hard to cheat. I mean, it's a cliched statement, but it's accurate. So that was already the case. But these two pieces of legislation actually make it easier for all residents in Georgia and Texas to get to the polls. Is that accurate?
I would say it is accurate. I mean, when you're talking about being able to, on your absentee ballot, certify that you don't have the necessary numbers, or provide that, if you have an ID number, if you have a social security number, who doesn't have a social security number? There are people who don't, but if you don't, all you have to do is certify that you don't have one.
Yeah.
I mean, who is this going to scare off? I would like to say just a word about voting fraud, Congressman, if I could.
Sure.
Voting fraud is hard to detect by its nature. It is not heavily penalized. My favorite example of this, no doubt, and I almost regret the day when they repeal this because I'll lose the talking point. But in Vermont, double voting is a $200 penalty, no jail time. And selling maple syrup without a license is $5,000 in a year in jail. Okay, why would you invest any state resources in ferreting out double voting in those circumstances? And there are states that admit they don't even track these, but that to one side. What I hate, what I don't like is when you say that it's rare because you take the total number of votes and you divide it by the instances of fraud. Is that how you'd measure securities fraud? There are only a couple of hundred securities fraud cases per year. There are how many millions, or is it billions of securities transactions?
Right.
But everyone knows that just because of the nature of the enterprise, you need rules. Okay, kitchens should be clean, voting should be clean, securities should be clean. And I also am mystified as to why people are aware that people will cheat at baseball. I read a book about people cheating at sumo wrestling. I have cheated at solitaire. And no one will cheat at something as consequential as voting.
Yeah, thank you. Thank you, Mr. Popper. Mr. Chairman, I yield back.
Thank you, Mr. Jordan. Who won those solitaire games, Popper?
I did, and I paid.
Thank you. Ms. Ross, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you very much for having this important hearing so close after the Supreme Court's decision. We have a lot of work to do on voting rights this session of Congress, and it's very important that we understand the law and do the right thing. I want to talk about the state of North Carolina. As a former civil rights attorney and a state legislator in North Carolina, I've seen up close the hidden ways in which states and localities can restrict citizens' rights to vote, and I fought against them. I want to talk briefly about Thornburg versus Jingles, a seminal Supreme Court case that's been referred to, which upheld a ruling from a federal district court in North Carolina. Decided in 1986, it solidified the 1982 amendments to the Voting Rights Act and utilized several of the factors enumerated in the 1982 Senate report for how to consider potentially discriminatory laws. The Supreme Court affirmed what the district court in my home state had found, that the essence of a Section 2 claim is that a certain electoral law, practice, or structure interacts with social and historical conditions to cause inequality in voting opportunities. In Brnovich, the court turned away from this interpretation, narrowed the scope of Section 2, and subverted Congress's efforts to clarify the Voting Rights Act. I fear that this decision will embolden state legislatures, including my own, to enact more restrictive voting laws. And I have reason to have this fear. This is exactly the effect that Shelby County had on North Carolina's state legislature, which enacted a restrictive voter ID law and repealed other laws that had expanded the franchise and disproportionately targeted African Americans with surgical precision. This monster voter suppression law was later struck down after years of litigation. Congress must act to protect the bedrock of our American democracy, and I'm grateful for the suggestions from our witnesses on how we can do that. I look forward to voting on several of these suggestions. My first question goes more to the specifics of this effects test, and it's for all of the witnesses, though I'd like Mr. Stephanopoulos to begin. Justice Kagan cited the Senate report, which we've talked about, which was amendments to the VRA, which incidentally was signed into law by President Reagan. And she wrote, Congress meant to eliminate all discriminatory election systems or practices which operate designedly or otherwise to minimize or cancel out the voting strength and political effectiveness of minority groups. And that broad intent is manifest in the provision's broad text. Do you agree that Section 2 manifests Congress's broad intent to eliminate all voting discrimination?
I do. I think that with Section 2, Congress aimed to eliminate all significant and unnecessary racial disparities in our elections, and many of the court's factors in Brnovich point in exactly the other direction, frustrating Congress's intent and the language of the statute.
Thank you. It looks like Mr. Rosenberg has something to add.
Yeah, I would just add, and we set forth in our written testimony, that a basic canon of statutory construction is remedial statutes must be construed broadly. And Justice Alito and the majority in Brnovich did just the opposite here. Okay.
My second question goes back to this attempt to freeze in time what election laws were in 1982 by the Supreme Court. And I find that particularly upsetting because we've made so much progress on election laws, and Congress even has expanded ways to enhance the franchise, particularly with the Help America Vote Act. Do you think that there is any justification for saying that Congress has not indicated that we want to move forward with helping America vote, that the Supreme Court could hang its hat on? For any of the members. Yes, Mr. Morales Doyle.
No, I don't think there's any basis for that. I appreciate you bringing up North Carolina as an example. You know, the case you referenced, which found that the North Carolina legislature was targeting African American voters with almost surgical precision, involved changes to a number of laws, rolling back early voting, getting rid of same-day registration, things that didn't exist in North Carolina in 1982. And yet that, as the Fourth Circuit Court of Appeals held, is how states now intentionally go after voters of color. No one could question after that court's finding that was discriminatory, and yet using 1982 as a benchmark would send you down the wrong path. That is why these guideposts are so misguided.
Thank you. And Mr. Chairman, I yield back.
Thank you, Ms. Ross. Is Mr. McClintock with us? If not, is Mr. Roy with us? If not, is Mr. Owens with us? If not, is Mr. McCarthy with us? Well, how about Ms. Cheney? She doesn't count. All right, Mr. Hank Johnson's not with us. I think Ms. Garcia is next. Ms. Garcia with us? She having technical difficulty? Ms. Sheila Jackson Lee, you are?
Yeah. I am here.
You are here, and you are glorious and resplendent and recognized.
I'm delighted. Thank you so very much. Thank you for, as has been said earlier, for you holding this important hearing. I almost wish I could transpose myself to the United States Senate to be able to have at least a 7 to 10 minute moment of inquiry. But before I start, let me indicate that I've heard so many people offer the name of John Lewis on the other side or the other body, including Republicans. We happen to be this weekend naming a vessel, Navy vessel, after John Lewis, more than a tribute, but I hope most of the witnesses on this panel would agree with me that the greatest tribute to John Lewis is to protect the fundamental right to vote and to reinforce the basis of the 1965 Civil Rights Act, which is the 15th Amendment. So my inquiries will go along those lines. But let me also indicate that because of the inertia and inaction of the Senate, faith leaders and Black women gathered yesterday, of which I participated virtually, along with the Democratic Texas delegation, who, contrary to Governor Abbott, is working very hard to be able to insist that there must be action in the Senate. And to the extent that our chairwoman of the Congressional Black Caucus, Joyce Beatty, was arrested, some of us will intend to do such in the coming weeks, because John Lewis did believe in nonviolent civil disobedience, and we must act. I'm very glad that the House is acting, Chairman Cohen is acting, as we move on this very important legislation. I also want to follow up and pose a question. Mr. Popper, I believe I just want to make a comment, and I would like Mr. Rosenberg, Mr. Morales Doyle, to focus on these questions. I heard the line of questioning about Section 2, that it basically is used for partisan activity, partisan challenges, and is in essence of its own self a contributor to fraud. Would you respond to the value of Section 2, and that in your course of service have not seen Section 2 be used and manipulated by individuals who are trying to be partisan? Was a voter ID legislation partisan when in the state of Texas, there were at least 8 counties without DPS officers that would allow Hispanics and others to access for the voter ID? Would you go first, Mr. Rosenberg? And my time I know is short. Mr. Rosenberg.
Yes, thank you, Congresswoman Lee, and thank you for that question. I will say 2 things very quickly. Number one, you cannot use discrimination against people of color in order to achieve partisan goals. That is unlawful, it is unconstitutional, period. And Texas photo ID law, which I litigated, we proved that it was done with discriminatory intent and discriminatory results. And I'll turn over to Mr. Morales Doyle.
Mr. Morales, thank you so very much. Mr. Morales, would you take up the point of what I believe Mr. Popper said, is that Section 2 has only been used by those of us that engage in partisan litigation? Do you believe that that is what Section 2 has been used for?
No, I do not. Thank you for the question. Mr. Rosenberg, myself, and many of our colleagues do this work at nonpartisan organizations. Our goal is not to accomplish some partisan outcome. Our goal is to protect voting rights. That is the point of Section 2. And I would remind everyone that Section 2 and its amendments in 1982 were passed by bipartisan agreement in both houses of the legislature. The amendments in 1982 were signed into law by President Reagan. There's an amicus brief filed in this case in the Supreme Court by congressional staffers on both sides of the aisle from 1982, talking about their intent in passing this law and how it was being subverted by many of the arguments being made, which the Supreme Court ultimately took up. This is not a partisan goal that we have here. The goal is to protect voting rights. And I think sometimes folks are too quick to give the people who are passing these restrictive laws a pass, suggesting that they are acting only with partisan intent. We are talking about race discrimination. This law is meant to protect against race discrimination.
And unfortunately, it was obliterated by the Arizona case. Let me quickly raise the point of the big lie and the continuous representation of my colleagues on the other side of the aisle of fraud in the 2020 election where 150 million people voted. Let me quickly ask one question for Mr. Rosenberg and Mr. Doyle and the other gentleman whose name I don't have right now because of where I am. But in any event, can you just give me a yes or no question? Is the filibuster, and Mr. Rosenberg, you can go first, is a filibuster part of the Constitution, yes or no?
It is not part of the Constitution.
Mr. Morales Doyle?
No, it is not.
Mr. Popper? Is it?
No, it is not.
And there's another witness there that doesn't show up on my screen. Forgive me. Can you answer, sir?
Yeah, of course, the filibuster is not part of the Constitution.
And so let me just go back to Mr. Rosenberg and Mr.
Time is expired. Be okay.
Pardon me?
Your time's expired.
Can I ask for it on the record and then I'll look for an answer later?
Sure.
All right. I'd be interested in knowing, and this is a global question, the fundamental right to vote has been evidenced by our president, and pursuant to the 15th Amendment, I'd like an answer as to whether or not the filibuster, which is a rule, would be superior to that right, therefore blocking fundamental voting rights legislation from going forward in either, well, in the United States Senate. I want to put that on the record. I thank you, Mr. Chairman, and I hope I will be able to get answers from these distinguished witnesses. Thank you.
Ms. Jackson. Ms. Garcia is not with us, so if that's the case, we've expired our time. We thank the witnesses extremely for their thorough testimony and their help. We appreciate your appearing. Without objection, all members have 5 legislative days to submit additional written questions, and Ms. Jackson Lee has submitted her first one, but that will come in writing as well, or additional materials for the record. With that, the hearing is adjourned. Thank you.